Once again, from the studios of UNO Television on the campus of the University of Nebraska at Omaha, consider this, a program of issues and information behind today's news.
The sign says Safe Haven, but the state says this nonprofit in Gehring, Nebraska is anything but safe for clients and their money. Police say the owner, Judith Widener, plundered the bank accounts of blind and disabled clients she had guardianship over. One red flag for the state auditor, her involvement in more than 600 cases, from 116 in Scotts Bluff to 32 right here in the Omaha Metro.
I thought to myself, how in the world can someone be the legal guardian for hundreds of people at the same time?
According to the audit, Widener had signature authority over 40 different bank accounts with a balance total of more than $600,000.
Basically, he's taking money from different protected people, or sometimes it was someone who had deceased.
The Scottsbluff County attorney says she's only charged with stealing a few thousand.
I think right now the total that we're comfortable with is closer to 10 or 12.
The investigation is far from over. Auditor Foley's report shows Widener deposited state checks into her business account written specifically to her clients.
The accounting records reveal that she paid herself $500 Christmas gifts, $500 birthday gifts, and we've also seen some evidence of her involvement with casino gambling.
During questioning, the Nebraska State Patrol says Widener admitted to using money earmarked for clients to pay for personal expenses.
HHS, for its part, ignored a number of glaring red flags.
Our thanks to KETV and reporter Dave Roberts for that story, which aired back in November of 2013. So where are we today with this issue? Hi everyone, I'm Kathy Wyatt. Welcome to this week's edition of Consider This. Our topic, the Public Guardianship Act. Joining us to talk more about it is Catherine Bellman. Catherine is the director of CLE, or Continuing Legal Education, for the Nebraska State Bar Association. Thank you so much for being here and welcome.
Glad to be here. Thanks, Kathy.
Public Guardianship Act.
Yes.
What is that?
It creates the Office of the Public Guardian and also creates the opportunity to develop regional assistant public guardians. The purpose of the public guardian is to be able to step in and find guardians for people who don't have family or friends to look after them if they need to be cared for because of disability, illness, those sorts of things.
Okay, so let's talk about a few terms here. When we say the word guardian, talk about who that person really is.
A guardian is a suitable adult, often a family member, who is legally responsible for an adult who cannot make a lot of the decisions of daily living because of illness or impairment. And it's a court proceeding, so the guardian has a relationship with the person who's protected, who is the ward, and the guardian also has a relationship with the court because the guardian is appointed by a judge.
Okay, and let's talk for a minute about the conservator.
The conservator has a similar relationship to a protected person, but they are responsible for the person's estate, for any money or property that that protected person has, but that they cannot make decisions about because of illness or impairment.
Okay, and oftentimes those terms come up when people maybe have not gone the route of something we call powers of attorney.
Right.
Talk to us about just that broad, I guess, definition first, and then we'll break it down a little bit.
Well, a power of attorney is a document executed by an individual, often written by a lawyer, but sometimes people write them themselves, giving another person the authority to make certain decisions for them. And it can be very broad or it can be very narrow. It can be limited to, I give John Doe the authority to sell my car for me. Or it can be very broad, that in case of, in case I can't make these decisions myself, I entitle John Doe to make them for me.
Okay, and so we have healthcare and financial.
Right.
Differences may seem obvious, but tell us a little bit more in terms of what the responsibility.
Well, the general power of attorney, which can include financial matters, comes under one statute, and then a different statute allows for the healthcare power of attorney, where you specifically have in the form that if something should happen to you, that you're ill or injured and cannot communicate your desires to your physicians, then you empower the person named in that power of attorney for health care to do that for you.
Okay, and same thing would apply with the financial. When should people get these? When should they be thinking about these legal documents?
People should be thinking about powers of attorney when they're still healthy, when they're still able to make decisions for themselves. They should at least say, well, what if something happened? Who would I want to step in and help me? And they can do that while they're still competent.
And Catherine, who would be a good person for people? I think oftentimes when we're really thinking about folks that would step in for us at that time, we tend to go to relatives,
yes.
Sons, daughters, that type of thing. But that's not always going to be what's in the individual's best interest. So what are we looking for in terms of traits when we're selecting someone?
Someone you can trust, someone whose judgment you trust. You can name successor powers of attorney. Say you name your brother as a power of attorney and something happens and he can't do it. Well, if you've already made a successor power of attorney, then that person can step in. But it should be someone who you find very trustworthy.
Okay.
And it could be a friend.
It could be somebody from your church. I mean,
it doesn't have to be a relative, but I think trust is an important element, as we've seen from recent news events.
Mm-hmm. Absolutely. And these are documents, like so many others, that should be reviewed, possibly updated, on a pretty regular basis.
Because people go on in their lives, and somebody may pass away or become incapacitated. Something might happen, and you might want to change who your power of attorney is.
Okay, and you brought up that word incapacitated. We hear that quite often. Specifically, what is the definition for that word?
The statutory definition, I can't quote it exactly, but it goes approximately that you're incapacitated if due to a physical or mental impairment you cannot perform the functions of daily living or make decisions on your own behalf. And it can be due to an injury, an illness, processes of aging such as dementia, and it can happen at any age. Any person of any age can become incapacitated.
That's pretty serious stuff, really, for us to be thinking about. We don't want to, but
right.
We need to be thinking about that, because when we talk in terms of power of attorney, for example, that's a huge responsibility. Somebody's going to come in and speak for us when we are no longer able to do that ourselves. And you talked a little bit about a power of attorney can be a pretty simple document,
yes.
or it can be pretty detailed. And I really want you to kind of, I guess, drive home the point of that document really existing to protect you and how important the language really is.
It's very important. It's created by statute. And the statutes say that whatever power of attorney you choose to do, it should be substantially like the language in the statute. It needs to follow it. You can select certain provisions. You might not need them all because it can get quite long. But you really need to pay close attention to the statutory language. So many people go to lawyers to have those things drafted for them. A person could draft them him or herself, but you really need to follow the statutory language. It's very, very important.
And the people find that language where?
In Nebraska Revised Statutes, Chapter 30 of Nebraska Revised Statutes, that covers everything dealing with the estate of the person, probate, wills, powers of attorney, guardianship and conservatorship.
Because Catherine, the laws change, right? And it's tough for people to stay on top of all of that. And I think one thing that would be very, very important to point out here, especially when we're talking about the importance of language, is the privacy laws. And one of the reasons people need to take that extra step and get this accomplished is because we don't live in a day and age where people can openly share information now with folks. It's very specific, correct?
That's right.
So HIPAA, people hear that term quite a bit, especially if they have a loved one in a hospital or a nursing home or whatever the case may be. What is HIPAA, Catherine?
It is the Patient Privacy and Portability Act. It really prohibits doctors from giving out information about a patient without that patient's express permission. And executing a power of attorney would be one way of giving that permission so that the doctor knows he or she can talk to that power of attorney. Okay. But it's to protect the patient's privacy. It's one reason, if you've ever served like on a church committee that visits the sick, it's much harder nowadays to find out who in your congregation is in the hospital.
It is very difficult, and that is why, again, it's so important that we take that extra step, or maybe have documents available to our parishes, our churches, to make sure that people know it's okay to share that type of information. Protection is what it's all about, and as you said, if you take the effort, make the effort to get the power of attorney, you're in control.
That's right.
Right? You're making that decision.
You've decided how much authority you want to give to somebody and under what circumstances, and you can also revoke it at any time.
Okay, so
it really leaves you in the control.
Okay, and if people don't have those, that's what we want to stress here, then they go down the path of what we opened the program with, and that is the guardian conservatorship route, which can be more difficult. We're very blessed that we have that, but talk to folks truly about the difference there. I want to paint a picture of what those circumstances would be like if somebody had to go down that path.
Well, say you were in a severe car accident and you had a head injury. So you could do some things for yourself, but there are a lot of things you just can't do anymore. Maybe writing checks or making appointments. It is very likely that a temporary guardian might be appointed for you. And it would most likely be a family member, but it could be somebody who isn't a family member. But their responsibility would be to make all these decisions that you can no longer make. They would decide where you live, when you see your doctor, how your income is handled, how your groceries are purchased. I mean, it's just going to depend on the level of whatever that person with the injury can do and what he or she needs help with. Now, I said temporary guardian because people can improve if they've been injured, and it may not be always necessary to have one. But sometimes then those temporary guardians turn into permanent guardians if the person doesn't get better. But they make all those decisions about living, where you live, what you do, who you see, what your activities are, that you're used to making for yourself.
Yeah, all the while you're incapacitated.
Yeah.
Right? So take us through this process. We haven't done the power of attorney, so we have no one to speak or act on our behalf. There's a circumstance which happens most likely beyond our control. Then walk us step by step through the process, and get us to the point where someone's been appointed and acts for us.
Okay, normally the family will step in and get a lawyer and petition the court to appoint somebody in the family as the guardian. And usually they've talked about it and hopefully agreed, who that person should be. Sometimes a person is all alone in the world and there is no relative, and at that point we have an organization called Adult Protective Services, and they may step in to try to find a suitable person to serve as that person's guardian. And that's what the process is right now.
Yeah, and it takes a while. It's not just an overnight thing, and it's usually more expensive in terms of the financial piece than a power of attorney would be, and you're not making the decision when you're able to do that.
That's right.
So those are the big drawbacks in that particular case, correct?
Correct.
Okay, so we're hitting that so far. And you brought home a good point here. There are a lot of people out there who don't have folks to speak on their behalf, and I think sometimes even those who do, it can turn into somebody that maybe you didn't trust or you didn't know as well. So we have now this Public Guardianship Act.
Yes.
Nebraska, the last state in the country to get this. Why is that, Catherine?
Well, I think the introducer of the bill, Colby Koash, said it quite well. He said, this state has a small population, or it always did, and we were mostly able to take care of our own. Families were able to step in. But populations change, there are more people who are really on their own now, and it was needed.
Yeah, so at the end of the day, recap what that means for us now to have that and when it's actually going to kick in.
The act will take effect January of 2015, and when people are petitioning the court to appoint a guardian, if it appears to the judge that there's no one suitable, no one from the family or friends to serve as a guardian, the judge can refer that case to the Office of the Public Guardian, who will then go about finding a suitable person and will supervise that process.
Now this office will have a director, and it will also have 12
assistant directors
scattered, sprinkled throughout the state.
Yes.
And talk to us about why it was set up that way and
Well, the goal is to be able to reach people in their communities where people know them and where the guardian can work with the whole community, work with the people in the family. It's probably best for people not to have long-distance guardianships. You want the guardian to have a relationship with the person who's protected. So that's one reason for doing it, to reach all across Nebraska and reach out to people. There will also, I believe, be an outreach coordinator whose job will be to help guardians through education and advice.
Well, and that's your bailiwick, right? Is education,
well,
right? So
that's kind of what our volunteer group does now
Yeah.
for the Extension Division. But there might also be a component of the Office of Public Guardian that also will do that outreach and education.
Okay, so let's talk education for just a minute. It's not like, one of those things where I say, hey, Catherine, you're going to be my guardian now, and you just step in and kind of do things. There's training involved in that.
There's training. It's mandated by our court system, and every person who's appointed as a guardian or conservator needs to take a 3-hour course. And it's taught in Lincoln, in Lancaster County, through the Extension Division at UNL. And it's a 3-hour course. It's team taught by an extension educator and an attorney. So and the attorneys are all volunteers. They come and just help to answer questions. And we usually get 20 or 30 people every month who are new guardians, and we walk them through the process so they know what their responsibilities are. And we also try to answer any questions they may have.
What are the most commonly asked questions for these people who are just coming in and thinking, I want to be a goodwill ambassador. I want to try this out. What are they asking you guys about?
Well, it's changed a little bit over the years, but the most frequent questions involve, what are my responsibilities to the person I'm taking care of? What is it appropriate for me to do or not to do? And please explain the reporting requirements, because they've become quite large. And that's what we spend a lot of time on.
I think that is one of the most surprising things for folks with whom we visit when we explain the difference between the more proactive, the power of attorney versus the guardian. There is a reporting expectation.
Right, because the court will oversee that guardianship, and you have to report annually. You also have to report at certain points where things happen. If the ward is going to be moved, that has to be reported to the court. They want to know where that ward is and how that person is doing.
And so for the person who's kind of tackling the financial piece of it, there's reporting to be done there as well.
They have an obligation to keep good records and keep track of things, and it's often quite challenging.
Well, yeah, Catherine, and you have to, in just having this discussion, you can understand, doesn't make it right, but you can kind of understand how things kind of get lost in the system. I'm not saying that that's right, obviously, but there are so many people out there serving in this capacity, and oftentimes under extenuating circumstances, right? So how is it that we're able to keep the tabs that we need to keep on those folks who are representing other people in these cases?
So far, I mean, the system has only been in place a short time as far as the newer guardianship rules, court rules, and procedures. The goal is transparency, and people get information packets. So depending on the kind of guardian or conservator you are, there's like 5 different configurations. Mm-hmm. You will get a packet of papers. You can get them right from the court, right from the Supreme Court's website, and hopefully that and the training explains to you what it is you need to do and when you need to do it.
Okay, and if a person gets into this situation, they come in and they believe this is something they want to do, and then they find 6 months into it, not for them at all, then what's the procedure?
They can go to the court and ask the court to remove them as guardian and replace them with someone else. And that's always a possibility.
How often does that happen, Catherine?
Once in a great while. It doesn't happen that often, but it does happen occasionally. Okay. Someone gets overwhelmed. Okay. It's a big responsibility. And these family members, I've seen mostly family members, they're just very generous to step up to the plate and take care of their family member.
Yeah, it's quite a task. Now, this Public Guardianship Act, right? A lot of benefits, but just kind of paint a picture for us in terms of, take it through all the people who are impacted, from the courts to the individual. How is that going to be beneficial to the state?
It's going to help a lot of people, particularly the protected person who has no one to turn to. At least there will be some insurance that that person is going to be adequately cared for, because people can slip through the cracks. There are people living on the street now who probably need guardians. They're mentally ill, or they're physically addicted, or there's something where they cannot function, but if nobody knows about them, mm-hmm. they can't help them. But it will help It helps the court system because the court system is making sure it's adequately informed about what's going on with all of these people who have guardians or conservators. So it makes that run more smoothly. There's an annual review. So when you file your annual inventory every year, they'll take a look at it. If there are any red flags, they'll ask you about them. Mm-hmm. But at least the idea is transparency, that the court knows what's going on with these protected people, that they can communicate it, and I think it helps everybody in the long run then.
Very good. You said something really important there, Catherine, that there are a lot of folks out there, many folks, who are unprotected, and they're in situations, they're living in their homes alone, maybe there is dementia at play there. If I'm an individual and I suspect that someone has progressed far enough, even if they haven't, just to be proactive. You mentioned adult protective services.
That would be the logical place to go.
The first call that people should make, and we really need to stress here what adult protective services role really is, because I think oftentimes people think if someone's in trouble I can call them and it's all going to be handled. Well, if the person is independent, able to make decisions for themselves, right, there's going to be a difference in how APS can act.
Yes, there will be.
So talk about that, because I think that's important. I think we have people who want to help so much. They have a neighbor. That neighbor's able to make decisions. So regardless of what's going on in that home, if that person says, I'm fine, we're limited in what we can do.
Well, they investigate people who might be in danger, either because they can't take care of themselves or because maybe they're experiencing abuse or exploitation. And they'll investigate that and report it appropriately and take whatever action they're empowered to take.
Okay, and so that Office of Adult Protective Services is there for the vulnerable, incapacitated, right?
Right.
Not able to make their own decisions. If we suspect there's something going on outside of that, where do we call?
Oh, that's a good question. Probably your county attorney.
Okay.
I think once the Office of Public Guardian is set up, you could probably call, if they have an outreach coordinator, you could probably call that person just to find out where would be the best place to go. But if you suspect that an older person, which is what we're mostly talking about, is in any way being harmed, you should probably report it either to Adult Protective Services or to your county attorney.
Okay.
And they could take that step. I know in some states, in Los Angeles, there is the district attorney, they call them, who is specifically assigned to handle only those cases. And he keeps very busy, as you might imagine.
Well, it's nice to know that we're taking the steps. I know I read someplace where this was a victory, right? A major victory,
yes.
Because we really do have an aging population coming down the pike here, and we have to have systems in place.
Yep, it's our demographic.
Yeah.
We boomers are rapidly moving through middle age.
So if you could anticipate then moving forward, what might be the next step down the road here? I mean, it took us a while to get this, this particular thing put into place. What might be coming down the pike as our population ages, do you think?
Well, I think we hopefully will develop the capacity to ensure that anyone who needs help can have help. One goal, though, of any kind of protective proceeding is to provide the least restrictive setting possible. So people can be helped on a whole spectrum of things. A guardianship or conservatorship might be very limited. Maybe that older person just needs help with balancing their checkbook or handling certain financial matters, but they're doing fine in all other areas of their life. Hopefully we will have the capacity to make those assessments and to help people only to the extent that they need help, and not impose it on them if they don't need it.
Okay. Now, as someone who serves in your role, CLE, right, what are some of the other things that you're seeing come into play here? Questions that are being asked, maybe in this particular instance, but maybe in some others, because you really do have a broad scope here. And so what are some of the other issues that we're talking about right now?
Well, one of the other issues is we follow legislation for one thing and do training when new things come up, when new legislation is passed. But in our estate planning and our elder law areas, we're seeing a lot of education on issues involving dementia, for example. Communication with your client when you suspect your client is incapacitated, and what a lawyer ethically needs to do or not do. We're seeing a lot of issues with long-term care planning, estate planning, that kind of thing. We see more people who are taking some thought about that as we come out of the recession. They really want to plan ahead and ensure that they or their loved ones are cared for.
Catherine, what is the difference? We have this question posed quite a bit between an attorney and an elder law attorney. And when we hear elder law, do we just automatically assume then that that individual knows older adults, understands, what's going on in that particular realm? Often get asked the question, how do I know if the legal documents are so important in protecting myself today and down the road? How do I know? What's the first step I take in finding the attorney that's right for me?
Well, it depends on what your situation is. An elder law attorney is often chosen by the family. They're people who specialize in working with older people. Often that's their preferred clientele. Sometimes they have experience or background that goes beyond just their legal training, and they have a special devotion to that. Now, also, some people really just need an estate planner, because really their concerns are more for how their estate will be distributed to their children and grandchildren. And there are lawyers who are estate planners, many of whom also do elder law, and some who really are more just general estate planners. And it really just depends on the individual's situation, what they need, and what their concerns are.
Okay. In the minute we have remaining, I have to ask this question. So,
Sure.
CLE director, why on earth? How did you fall into that? And why are you excited about your job?
Oh, I love working with lawyers, and I'm a lawyer myself, but I stopped practice a few years ago to join the bar staff, and to have this opportunity to work with lawyers and to help them maintain their competence by providing classes. I rely on volunteers to actually be the expertise for those classes. I just help organize it and work with them, and it's a real joy.
And in a nutshell, the State Bar Association is what?
It's an association of lawyers. All lawyers in the state are members of the Bar Association. Some are more involved than others. But the Supreme Court regulates the Bar Association, so we work very closely with the court staff and with other professional groups in the state, and we try to help lawyers serve their clients in the best manner possible.
Awesome. Okay, well, we do have a graphic that we want to put up for folks in the event that they would have more questions about this particular topic today. It is disabilityrightsnebraska.org. Catherine, thank you so much for being here today and for sharing your time and expertise and bringing us up to speed on what's going on with this issue.
Glad to do it.
You bet.
Thank you.
And thank you all for watching. We'll see you next week.
Consider This is an issues and information program produced by UNO Television. More information can be found at unotv.unomaha.edu. If you'd like to share your comments about this show, call UNO TV at 402-554-2516 during regular business hours, or email us at considerthis@tvmail.unomaha.edu.